Good afternoon. Thank you for being here today. It is 2 p.m. on Wednesday, September 3rd, 2025, and this is the scheduled time for the workshop to solicit comments regarding proposed changes to Chapter 555 of the Nevada Administrative Code. This workshop is being held in person at the Nevada Department of Agriculture headquarters in Sparks, Las Vegas, and Elko offices, and virtually on Microsoft Teams for all who are interested. This workshop has been properly noticed and is being recorded as required by Nevada Open Meeting Law. My name is Ray Saliga. I am Deputy Administrator for the Division of Plant Health and Compliance. The following staff members of the Department of Agriculture are also present for this workshop. Megan Brown, Administrator for the Division of Plant Health and Compliance. Vance Lum, Environmental Scientist 4, and Diane Reese, Administrative Assistant 3. I'd like to quickly review the rulemaking process so you have some background on what has been done and next steps. As a first step, the NDA reviewed the existing NAC language, updating sections due to R12723. The proposed regulation reduces burden on existing licensed businesses and individuals new to the pest control industry by providing a training period in which individuals may apply pesticides while completing the licensing process. The supervision, training, and information exchange requirements of the proposed regulation ensure that trainees are equipped with essential information necessary to protect themselves and the public and to maintain compliance with state and federal law during this training period. The revisions to NAC 555 contained in R12723 implement regulations required by SB 159 of the 82nd Nevada Legislative Session. R00525. This proposed regulation is intended to assist the department in modernizing the reporting of wood-destroying pest inspection forms. Physical wood-destroying pest inspection report forms are currently provided by the NDA to industry free of charge pursuant to current regulations. The NDA anticipates the modernization of providing digital platform to industry to complete and submit wood-destroying pest inspection reports will benefit both the industry as well as the department. Current regulation requires the use of digital signatures for electronically submitted reports. Updating the type of signature required will enable the department to utilize existing technologies and department resources to modernize this process. The drafts we're reviewing in this workshop are the most updated version of proposed changes and are found in the LCB files 127-23 and R005-25. The department then distributed a small business impact survey for industry input. That information was compiled and a statement was included with this workshop notice. This workshop is being held to review proposed changes and receive public comment to help shape the final proposed language. Additional comments may be submitted following the workshop. If deemed necessary, the NDA may choose to hold additional workshops for input. Following the workshop process, and once the Legislative Council Bureau has provided input and approval to move forward, a hearing and attempt to adopt proposed regulations will be scheduled and noticed. Public comment may also be made before, during, and for a specified period after the hearing. The draft resulting from the hearing process is then adopted by the NDA and submitted for review and approval by the Legislative Commission. After approval by the Legislative Commission or Subcommittee to Review Regulations, the Legislative Council Bureau will file the regulation with the Secretary of State. This is the point the adopted regulation would become effective. A few housekeeping items. We'll ask those who are present to please sign in, even if you do not intend to speak. For those joining us online, we'll be using some of the features of Teams for those who have joined us through the platform. Both to mute and unmute, raise hand, find the chat box, etc. We've muted everyone to reduce background noise. If you wish to give public comment, please use the hand raising feature in Teams and we'll call on you to ensure the mic is unmuted. Those on the phone can unmute themselves when called upon by pressing *6. If you have any technical issues during the meeting, try the following. Turn the video off to see if your connection improves. Leave the video meeting and either try to rejoin or call in using the call-in phone number and login information from the agenda. If you're having problems getting unmuted or into the comment queue, use the chat function to make your comment It will be recorded for the record. In addition to public comments during this workshop, interested parties are welcome to submit written public comment and send via email or mail to the addresses included on today's notice and agenda. If you are online, we'll be using the participation list. If we're unsure of your name, we may send you a chat, so we'll have the correct information in the meeting minutes. If you're joining us via phone, we'll now ask you to state your name and any affiliation for the record. Do we have any phone-in attendees?
No, we do not.
From our agenda, we'll start with a period of open comment for anyone wishing to speak on concerns or to provide input. This time is meant to collect your statements of feedback, and workshop organizers will not respond to comments provided during this time. As such, we invite you to hold your questions until that point in the agenda. Please limit your comments to 3 minutes to ensure everyone can be heard. As moderator, I'll interject to notify you if you've reached 3 minutes so you can conclude your following remarks. Following open comment, we'll review the proposed changes to NAC 555, followed by time for questions and clarification. After questions, there will be another period for additional public comment on the proposed changes. Those who wish to speak during public comment are requested to indicate their interest to speak on the sign-in sheet, and those virtually by use the hand raising feature. As a reminder for anyone who has joined on the phone, you can raise your hand by pressing *5, and once you've been called on, you can press *6 to unmute yourself. When called upon, please identify yourself by name and any affiliation for the record. Again, please save your questions for after public comment at the conclusion of the review of proposed changes. There will be time for questions and dialogue at that point once all information has been shared and before we move into the next round of public comment. The department is proposing changes to Nevada Administrative Code, Chapter 555. These regulation changes are necessary in R127-23 to reduce the burden on existing licensed businesses.
Ray. So we need to open public comment first before, and you're not sharing the agenda, just the telephone numbers.
Thank you. Do we have any opening any comments for the opening public comment period?
Ray, just a point of clarification, Warren Hardy, representing the Nevada Pest Management Association. So there'll be an opportunity after public comment to comment on the regulation, or is the public comment period my time to comment on the regulation?
You can comment on the regulation now. We'll also hold a discussion period where you can ask questions, and
What would be your preference?
If you'd like an answer, then I'd be happy to address that during the discussion.
Okay, we'll wait to discuss. I do have a couple of comments and then one question, so thank you for that.
Do you have any other?
Ray, this is Megan Brown for the record. Can you please read what is on the agenda next to the public comment agenda item? And then we can, if there is no public comment, then we can move to the next agenda item.
Okay. In consideration of others who may wish to provide public comment, please avoid repetition and limit your comment to 3 minutes per person. Unused time may not be reserved by the speaker nor allocated to another speaker. No action may be taken on a matter raised under this item of the agenda until the matter itself has been included specifically on an agenda item, which action will be taken. If there are no other comments, I will move on to the overview of the proposed changes to Chapter 555 of the NAC.
Ray, this is Megan Brown for the record administrator. Can you please check with each of the offices and with me about remote attendees, and then we can move on to the next.
Do we have any comments? Anyone who would wish to comment in the Sparks office?
There are no attendees at this time in the Sparks office.
Would anyone wish to comment in the Elko office?
There is no public in attendance in the Elko office.
And would anybody on the phones or join virtually like to submit a comment?
At this time, we have nobody joining virtually.
Thank you. I will now review the overview of the proposed changes to Chapter 555 of NAC on the proposed regulations for R127-23.
Ray, I think I'm the only member of the public here, so I don't necessarily need a comprehensive overview unless you feel required to provide it.
Per open meeting law, I'll need to review. I can do that quickly. R127-23 amends, as discussed, Chapter 555, defining the term applicator trainee, and sets forth the requirements for a certificate of registration as an applicator trainee, setting forth qualifications for an applicator trainee, and providing some requirements for training and information exchange for the trainee. It revises some provisions to governing continuing education, revising the schedule of administrative fines to include certain fines specific to an applicator trainee, exempting applicator trainees under immediate supervision of licensees from prohibitions on the application or use of restricted use pesticides, repeals a few certain definitions, and provides other matters properly relating thereto. I'll briefly review each section that has been modified. So, Section 2 defines the term applicator trainee. Section 3 establishes some qualifications, the qualification for a person to register, the categories in which they may register, application requirements, and provides a 90-day certification registration period. Section 5 requires an applicator who supervises an applicator trainee to provide certain training materials and to keep records documenting the training. Section 7 regulation applies to existing definitions, and Section 2 governs applications of pesticides pursuant to Sections 3 through 6. Further requirements ensure that the person has a license on their person. Well, for licensed applicators, registered trainees would need to display this license as on their person prominently. We'll briefly go through the requirements. As mentioned in Section 2, requires an applicator trainee to register. They must be 18 years old. They must be employed by an existing pest control business, and they must submit an application to the department. They may only register in the categories of limited landscape, industrial, institutional, or weeds. Each application for a certificate of registration as an applicator trainee must include contact information for the person, the name of the business they're applied, an endorsement by a primary principal, location principal, or principal of the pest control business, and include a statement that a supervising applicator or pest control business is responsible for the actions of the trainee, that they'll receive certain training materials in Section 5, and a statement indicating that they have not been previously registered as a trainee. I'll also denote the categories in which they are going to engage in pest control and whether or not they're licensed in another state. Every person in commensurate with our existing law, if there's a change to the registration status or employment status of the registered trainee, they need to provide that to the department within 15 days. And each applicator who supervises a trainee must provide specific training information and ensure that they understand the general standards of practice as outlined in NAC 555-400. Training requirements are listed here. They are commensurate with federal training requirements for applicators who work near or around pesticides on farms. In addition to providing essential training to the registered trainee, they must maintain documents documenting the training provided to the applicator pursuant to this section. Registered trainees must have a means to immediately and directly communicate with the supervising applicator, access to the product labeling of all pesticides carried by the applicator trainee, and if they're using restricted use pesticides that require immediate supervision, a supervising applicator must be present with them during the application. The supervising applicator must also provide the trainee with clean personal protective equipment, appropriate instructions for mixing, loading, and transferring pesticides, and instructions for the application of each pesticide that will be applied by the applicator. So this includes product labeling instructions, precautions, site or use specific requirements, and information how the risk of adverse effects may be increased or decreased by the characteristics of the site, such as surface water, groundwater, endangered species, or local population, and maintain the condition of the application, such as the equipment, method of application, or formulation. Further changes, proposed changes, update existing language to reference the sections that we have just reviewed. We've also included in this proposed changes, changing the name, referencing the Nevada Pest Management Association, updated to their current name of Nevada Pest Management Association. Further changes in section 11 add references to applicator trainee for existing requirements for licensed operators and principals. We also add references as registered to include when mentioning licensing requirements. Applicator trainees may use general use pesticides when under the direct supervision of a licensed applicator. This means that the licensed applicator does not need to be physically present, but must be available. Restricted use pesticides only when under the immediate supervision of an authorized commercial applicator or other individual. Immediate supervision requires that the person is physically present during the application. Additionally, in this update, we've updated the price referenced for NPMA Form 99B to reflect the current pricing available through third party. And we've provided for updates in the Schedule of Administrative Fines in NAC 555-530 to reference applicator trainees in addition to licensed individuals. We've added 2 additional entries to our Schedule of Administrative Fines. One is for engaging in pest control activities as an applicator trainee without holding a certificate of registration issued by the director. This is in line with current fines for unlicensed pest control activity. And we have another entry providing for violation, a fine for violations for failing to carry the certificate of registration issued by the department while engaged in pest control. It requires that it is displayed on the person. We've provided definitions for each of our sections within 555. We've also repealed two sections, the definition of location principle and a reference to the definition of principle, yet that definition stands. We will now take any questions regarding proposed changes to LCP file number R127-23. A quick reminder to use the hand raising feature or come to the table to be called on. Be sure to state your name and any affiliation for the record, and please keep your questions to 3 minutes or less to ensure everyone has a chance to be heard. As a reminder for anyone who has joined on the phone, you can raise your hand by pressing *5, and once you've been called on, you can press *6 to unmute yourself. Do I have any questions or comments in the Las Vegas office?
Am I still the only one here? I don't want to monopolize the time. Okay, thank you very much, and thank you for that overview. First question, in section 3, it says the person may register as an applicator only one time, which makes sense, and only in one of the following categories, limited landscape, industrial, institutional, or weeds. What was the thought process behind simply saying that we could only register in one of those categories? And I apologize if I'm displaying my ignorance of the industry. I didn't get a chance to ask my client about this, but so what was the reason behind limiting it to just one of the 3?
So in keeping with being a training period, to train, this enables someone on day one, after receiving training from the company up to company standards, to start performing pest control by themselves and doing work. So in keeping with that training period, rationale was to allow it in one category so they can focus on learning that specific category, the safety and the risks involved, and proper application techniques for that. So that,
which makes sense to me, but we're foreclosing on the opportunity if they want to be a trainee in one of the other categories in addition, because we're saying you can only be a trainee one time. If what we're saying is you can only be a trainee in that category one time, I get that. But if we're saying you've got to select for time and eternity, the one category you're going to get trained in, that has potential to be problematic. So is that the intent, that you have to choose at the beginning and you can never be a trainer applicant again?
yes, the intent is to enable them to gain the necessary skills and experience to pass the test and to do applications while they're learning. In speaking with industry, many new to the pest control industry learn by doing, and we understand that. So providing them the ability to learn and to gain the hands-on experience while they study to pass that test is the intent. The provision for one time is to enable that entrance into the industry, rather than annually or repeatedly using the training process to forego licensing.
So let me ask it a different way. Is it typical then in the industry for a licensed applicator, not an applicator trainee, a licensed applicator, to only practice in one of those 3 fields?
I don't have any statistics off the top of my head. They're the most 3 fields with the highest number of licensees in them. And people will, new licensees will generally take our general examination and then a category exam. And then once licensed, they'll take additional exams in additional categories.
But in order to to order for a licensed applicator to practice in those three areas, is it three separate exams? Is that?
It'd be our general knowledge exam and then an exam for each of those categories. Yes.
So the theory then, I'm still trying to get my arms around why we're limiting it to one. In theory then, let's say, I don't know what the most common is, I would imagine industrial and institutional. Once they've done their training in that, then as a matter of course, they can get certified or licensed to do limited landscape and weeds. So an additional training period is not really necessary. Is that what you're saying?
They would be licensed once passing the category exam and the general exam for industrial institutional. They'd be licensed to perform that work. They could, without holding a license in another category, go and learn that alongside a licensed applicator. They could also perform that work while studying to take that other exam.
So as it exists today, I want to become an applicator. I want to become a licensed applicator. I go in and I fill out an application to become a licensed applicator in industrial and institutional. And that's what I'm then licensed to do, industrial. If I at some future date decide I also want to get licensed in limited landscape and weeds, I can do that, but I can't practice that until I've passed the test.
You could not practice that by yourself without a licensed applicator with you.
So it's like
supervision.
And that's current law.
Correct.
Okay, so I have an industrial and institutional license. I start practicing that. My employer says, I'd like you to become proficient in weeds. Under the current law, I can go with a licensed applicator in weeds for training purposes.
Correct.
Okay. And I think, and again, I don't know, limited landscaping and weeds, a lot of that is restricted use.
There's the option to use restricted use, but much of it is general use. It's very rare we see
Okay.
restricted use.
Restricted use, even under the new regulation, requires somebody to be present. I'm going to reserve the right to go back and talk to my guys about that, and I apologize. I listen. Poor Miss Brown, I've been bugging her for a year to get this going, and now here I am asking questions. Okay, thank you.
And just to be clear, the proposed regulation requires direct supervision for restricted use. Direct does not mean that the person has to be physically present.
They have to be available. So to be able to get them on the phone, you have to be able to talk to them in real time as you're doing the, yeah, we put that specifically in the statute based on our conversations. So then that was my only question. So let me go back to my guys. It makes sense to me. Let me make sure I see what direction you're headed with that. Then the couple of things more comment related, and I do have to apologize. I should have brought some proposed amendments. What's not clear to me in reading this is when does the provisional license become effective? In other words, when can the person go out in the field? What training is required before that? What documentation? Are we saying all that has to be done before they can get the provisional license and go in the field? I just think that should be clearer in the regulation. So we clearly understand before you can go out in the field, you have to do A, B, C, and D. And then after you do A, B, C, and D, the provisional license become effective and you have 40 days or 90 days. Instead of saying the 90 days starts when you do the application, then you have to do all these things before you can get into the field. Does that make sense?
That does.
Okay. And the second thing is it's just a bit confusing to me. And again, I want to compliment you on how whoever did this regulation and translating it from the statute that we put together into an actual regulation. I think you did an amazing job. But there are some things that are a little bit confusing. I think it'd be easier and more provide more clarity. And I'll be happy to provide some language in the very near term because we're very interested in getting this on the books and in the field regarding what is actual training and what is the requirement to provide documentation. And then it says things like ensure that the applicant trainee understands the requirements set forth in NAC. I don't know how I can certify that they understand it. I can certify that they were provided the information. I can certify that they certified to me they understand it, but it's just little stuff like that, so is better, because we're taking on a lot of liability as the company and the licensed applicator. We're taking on the sole responsibility here. The problem with that is anytime you do that, that can be weaponized against you. If somebody gets mad at you, they don't pass your probationary state, they sue you because we didn't ensure that they understood these things. And so I just think it needs a little cleanup with regard to, here's the stuff that actually is a training requirement, and the 90-day period doesn't start until these things are actually done in a training capacity. Frankly, we're going to probably do most of that just to cover liability. And what stuff is providing them with information, because it sort of jumps back and forth between training and providing information. Like, for example, in section 5, subsection 1B, it says ensure that the certified applicant trainee has received training within the immediate preceding 12 months. Again, that should be certified that they've received training, although that's less problematic to say that they ensure it. But then in subsection C is provide the training applicator with training materials with all of the information to the applicator. So I think for us, it would be very helpful just in terms of making sure we can navigate our liability to say, this is training. You got to sit them in a classroom and you got to do this. Then you need to provide them with the documentation, which I think is, based on our prior conversation, is going to be most of what's in section 5, that we provide them with a documentation, and that they certify that they've read the documentation and they understand the documentation. But I think there's still some things that we're going to want to sit them down in a classroom and say, you were trained on this. You didn't just receive documentation, you were trained. So that's the only comment I have. It sort of jumps back and forth between those two things. And so if we could clarify that in regulation, exactly which of the two, I really think we're there. I'm talking to my guys. The training is going to be much broader than this. And I really appreciate you guys not overloading us and doing just what seems to be the bare necessity to me. But we're going to provide intensive PPE training and labeling training and all those things, because intentionally we set it up to where the liabilities with us, right? If we're going to take on the responsibility of training somebody has to be responsible and liable to the public, and we recognize that's us. We just want to make sure we're guarding against, you get a guy for 60 days, he doesn't work out, you fire him. Then based on the provisions of the regulation, he sues us because we didn't do what we were supposed to do. So I've had a motto in politics for the last 35 years in Nevada: just because you're paranoid does not mean they're not out to get you. So I try to be very paranoid, and I'd be happy to sit down and provide some language in terms of dividing that up. But I think it's very well drafted. It hits the intent of what we were going to put in the statute, and then speaking with Ms. Brown and Director Goycochea, the preference to do it in regulation was expressed, and I think you nailed it for the most part. So just some clarification.
And just to give you some background, section 5, we pulled the vast bulk of that language directly from federal CFR pertaining to worker protection standards. So it's the minimum safety requirements for people who work near pesticides on farms or apply them themselves. That was so that you could meet these requirements by providing an EPA-designed 20-minute video that covers all of these points. And we also can provide, which we do to farms, sign-offs sheets stating what information they were providing.
Well, maybe it would be helpful to actually reference that the provisions of this section can be satisfied by watching the EPA video or its successor. So anything we can get to clarify exactly what our responsibility is. I'm not worried about you guys at all. I just know how disgruntled employees tend to weaponize these things. And so the more clarification we can get about exactly what, and if it's the training is watching the 20-minute video in our presence, so we know they watched it, and certifying that we know they watched it, and then providing whatever we provide in writing. I think everything in section 5 is entirely appropriate. And as I said, just really probably the minimum that ought to be required. So I do appreciate you guys not jumping and over-regulating us, but we do want to make sure we're providing all the right stuff and that we're covered. So if you guys would consider that, you know, the provisions of Section 5 or I probably wouldn't want to put that in statute, but put it in regulation, specify a specific video or its successor. That's easy to go change if you need to. So anyway, that's sort of the general thought process here. Love the regulation. First of all, very grateful we're finally in this place where we're getting this done. This is going to be a game changer for the industry. The challenges we had during COVID were just unspeakable, and this would have just avoided those problems. So thank you all so much for your hard work here.
Do we have any questions or comments in Sparks?
Thank you. I was late to the meeting. I don't know, can you see me or do I move over here? I don't know if you can see me.
Your name and company.
Yeah, I'm Lee Loris. Okay, my company is Z-Best Pest Control. Just for the record, just for discussion purposes, I ran this program for 25 years here out of the Reno office. And this question's come up many, many times over my career here and post-career, working in the industry now directly, as to having a license or an ability for a company to license a guy without having to go through the whole testing process. It was always kind of my position and the position of the agency that we had a resistance to that because of public protection and education within the industry, proficiency, et cetera, and so forth. I understand that this has been passed to the legislature now for the agency to come up with a standard, a solution, a process by which to license people essentially that can't pass the examinations. Let's just call it what it is. And I think really what has to be understood is there's an element of compromise at this point. And I think that's what we're working on here between the agency and the industry to figure out how best to for the agency to administer this and the industry to accept it. Of course, with public protection being the number one concern in all of this. I did a written response to this to simplify it, because if this gets really complicated, and I'm hearing it here between the agency and the industry and what we have to do in the preceding 12 months and keeping track of this and training, it can get pretty complicated in how is the agency going to regulate this to its satisfaction and standards that it would require to ensure its safe application of pesticides. Really, I think some of the things that have been brought up here are really applicable to an easy management of this. One, how the individual passed the general examination. It's not that hard. It's not that hard to test. It's a 100-question test, and it covers laws, regulations, PPE, groundwater protection, endangered species. I can go on and on. 12 points covered in the label, plus standards of practice and things that have to be done. I think there's an assurance there that once they pass the general exam, much of the hurdle is done. Secondly, a video would be great. I produced the video for the solicitor's license. That's my voice in there for the guys that come in and have to get the license to sell pest control. Pretty simple, pretty easy to do. You sit down with the basic topics you want. You present it in a video. Guy comes in, takes the general test, passes it, and then sits down and watches a video for 30 minutes, 20 minutes. Gets all the points of understanding. They can do a test while watching the video, checking off the questions, answers, and things like that presented in the videos. And it's done. It's that simple. It's to make it this complicated, it is too complicated. And it's complicated for the agency, it's complicated for the industry. And I don't know necessarily that there's a standard that everyone is being measured by, like we have with the testing standards. Everybody's got to pass the test, right? So I just think that the opportunity is being missed to simplify this entire process. At the general, watch a video, check off questions, make sure the individual knows, have the principal sign a checklist that they've gone over these things, training and stuff like that. I think that's applicable here. When they apply for their limited license, I like the 90-day one time. I think that's great. But by passing the general exam, they're already a step to getting fully licensed, which is really the want of what the industry and the agency wants is a fully licensed individual so that we don't have to have concerns about all these particular subjects. So that's really where I would take this, would be to take this and make it much simpler for everyone. And I'd be willing to work with anybody on language. I wrote a lot of the laws that exist in here, regulations now, and I'd be happy to continue working on it.
Great, thank you for your comments. Do you have any other questions or comments in Sparks?
There are no other speakers in Sparks.
Do you have any questions or comments from Elko?
Megan Brown, for the record, no, there's no public comment in Elko. Or
And is there any online or via phone?
No, there's not. Megan Brown, for the record.
We have no further question or comment on R127-23. We will review the proposed changes to LCD file R005-25.
For the record, this is Megan Brown. Can you please refer back to the agenda? We will open public comment. We will adjourn this workshop and then move into the next workshop for the R005-25.
In that case, we'll open for any closing public comment.
Thank you again, Warren Hardy, representing the Nevada Pest Management Association. I don't think it's any secret that with the past administration, I had real issues with the way the department and the agency dealt with the business impact statement and following the provisions of that law. During my time in the state Senate, that was a delicate issue for me in that business impact statement. And I just want to say that I think the department has gone from having a virtually non-existent or at least not very good business impact statement process to having what I point to as the standard now in the state for how to do a business impact statement. So I just on a personal level want to thank you guys for being responsive to those concerns and more than correcting that problem. As I said, in my estimation, you've gone from the worst in the state to the standard, and what I tell other state agencies they should duplicate in their business impact statement process. So I just want to, as a moment of personal privilege, thank you guys for that. And also for this regulation. I will get you some specific proposed comments and amendments. And then we would just encourage, as we've talked about before, move this forward as fast as we can. We will go to both the board and to the legislative commission and advocate for the passage of this program. And I do appreciate the gentleman's comments. The statute's pretty prescriptive about what needs to be in the regulation. That was my intent. And so there will be other opportunities as the legislature meets to tweak that if we need to, but this certainly reflects what we anticipated and what we contemplated with the statute. So I wanted to just thank you all for that.
Do we have any statements or public comment in Elko or in Sparks?
Thank you. Sorry to interrupt. For the record, Lee Lawrence, the best pest control. I would be, I don't mean to sound like a radical because I know how difficult this stuff is. But it's really nice before things are drafted to this extent to have meetings with the industry to get input. And I don't know, I never received any sort of invite before the workshop draft of this was done. And I'm just going to say this. When I was writing regs, we would meet with the industry, north and south. I'd go down, fly down, sit with the guys, talk to them. Our board member was involved. I don't know where our board member is today, in the drafting as a liaison of the industry and the agency, in developing these regulations in a fashion that was agreeable really to everybody before we even got to the workshop phase. And evidently, I must be wrong because nobody's showing up in Vegas who really has any opinion on this beyond Warren there. But I would just say that if you guys are in the interest of developing other regulations, I would gladly come in and sit down with you guys and kind of go over stuff before they get printed in a workshop or now we go to hearing phase. And so, there would be, I think, more input because at this point, it's hard to make any changes. It's hard for me to have any credible advice, if you will, on doing this because it's so far in the process. So the next time the process is done on regulations, and I don't know if the agency is interested in hearing this at all. But this was the way that it was effectively managed in the past, where we had the industry in working on these things in a very early phase. And I appreciate all the work here. I don't want to sound that way. I appreciate the work you guys have done on this because I know how much work it is. I'm available for other stuff if anybody's interested in working on other regulations in the future. I just would like to make that point well known. Thank you.
Do you have any other statements or comments in Sparks?
This is Vance Lund from the Sparks office. For the record, there are no other speakers at Sparks.
Do you have any comments or statements in the Elko office?
Megan Brown, for the record, there's no public comment or attendees in the Elko office.
And any from callers or online attendees?
Megan Brown, for the record, no, there are no online comments or questions.
Thank you. Thank you all for your participation. The NDA will take the comments from you today under consideration, along with any written comments received during the rulemaking process. Following this workshop process, there will be a hearing for adoption of regulations scheduled and communicated. This notice of hearing will be posted not less than 30 days prior to the hearing date and will provide instruction on how to provide written comment and a deadline for submission of comment for the purpose of being included in the official record of the hearing for adoption. Thank you for attending. This workshop is adjourned as of 2:49 p.m.
Megan Brown, for the record, Ray, you can start with the call to order and opening for the proposed changes related to 555 in R005-25.
Good afternoon. Thank you for being here today. It is 2 p.m. on Wednesday, September 3rd, 2:50 p.m. on Wednesday, September 3rd, 2025. This is a scheduled time for the workshop to solicit comments regarding proposed changes to Chapter 555 of the Nevada Administrative Code. This workshop is being held in person at the Nevada Department of Agriculture headquarters in Sparks, Las Vegas, and Elko offices, and virtually on Microsoft Teams for all who are interested. This workshop has been properly noticed and is being recorded as required by Nevada open meeting law. My name is Ray Saliga, and I'm the Deputy Administrator for the Division of Plant Health and Compliance. The following staff members of the Department of Agriculture are also present for this workshop. Megan Brown, Administrator for the Division of Plant Health and Compliance. Vance Lum, Environmental Scientist 4. Diane Reese, Administrative Assistant 3. I'd like to quickly review the rulemaking process so you have some background on what has been done and next steps. As a first step, the NDA reviewed the existing NAC language, updating sections R005-25. The proposed regulation is intended to assist the department in modernizing the reporting of wood-destroying pest inspection forms. Physical wood-destroying pest inspection report forms are currently provided by the NDA to industry free of charge pursuant to current regulations. The NDA anticipates the modernization of providing a digital platform to industry to complete and submit wood-destroying pest inspection reports will benefit industry as well as the department. Current regulation requires the use of digital signatures for electronically submitted reports. Updating the type of signature required will enable the department to utilize existing technologies and department resources to modernize the process. The drafts we're reviewing in this workshop are the most updated version of proposed changes and are found in LCB file R005-25. The department distributed a small business impact survey for industry input. That information was compiled, and a statement was included with the workshop notice. This workshop is being held to review proposed changes and receive public comment to help shape the final proposed language. Additional comments may be submitted following the workshop. If deemed necessary, the NDA may choose to hold additional workshops for input. Following the workshop process, and once the Legislative Counsel Bureau has provided input and approval to move forward, the hearing and attempt to adopt proposed regulations will be scheduled and noticed. Public comment may also be made before, during, and for a specified period after the hearing. The draft resulting from the hearing process is then adopted by the NDA and submitted for review to the Legislative Commission. After approval by the Legislative Commission or subcommittee to review regulations, the Legislative Counsel Bureau will file the regulation with the Secretary of State. This is the point the adopted regulation would become effective. We ask all those who are present to please sign in, even if you do not intend to speak. For those joining us online, we'll be using some of the features of Teams for those who have joined us through the platform, both to mute and unmute, to raise hand, and chat function. We've muted everyone to reduce background noise. If you wish to give public comment, please use the hand raising feature and we'll call on you and ensure your mic is unmuted. Those on the phone can unmute themselves when called upon by pressing *6. If you have any technical issues during the meeting, try the following. Turn off the video to see if connection improves. Leave the video meeting and either try to rejoin or call in using the phone number and login information on the agenda. If you're having problems getting unmuted or into the comment queue, use the chat function to make your comment and it will be recorded for the record. In addition to public comments during the workshop, interested parties are welcome to submit written public comment and send via email or mail to the addresses included on today's notice and agenda. Since there's no sign-in sheet, as there would be at an in-person, if you're signed in online, we'll be using the participation list. If we're unsure of your name, we may send you a chat so we'll have the correct information in the meeting minutes. If you're joining us via phone, we'll now ask you to state your name and any affiliation for the record.
Megan Brown, for the record, there's no call-in attendees.
From our agenda, you will see that we start with a period of open comment for anyone wishing to speak on concerns or to provide input. This time is meant to collect your statements of feedback, and workshop organizers will not respond to comments provided during this time. As such, we invite you to hold your questions until that point in the agenda. Please limit your comments to 3 minutes to ensure everyone is heard. As moderator, I'll interject to notify you if you've reached 3 minutes so we can conclude your remarks. Following open comment, we'll review the proposed changes to 555, followed by time for questions and clarification. After questions, there will be another period for additional public comment on the proposed changes. Those who wish to speak during public comment are requested to indicate their interest to speak on the sign-in sheet, and those virtually by the hand-raising feature. As a reminder for anyone who has joined on the phone, you can raise your hand by pressing *5, and once you've been called on, you can press *6 to unmute yourself. When called upon, identify yourself and your name and any affiliation for the record. Again, please save your questions for after public comment at the conclusion of the review of proposed changes. There will be time for questions and dialogue at that point, once all information has been shared and we move to the next round of public comment. I'd like to open for general public comment. We have none in the Las Vegas office. Do we have any comments from the Sparks office?
For the record, this is Dan Sloan of Sparks office. Sir, do you have any comments?
I just have a comment here. Ray, I want to just one more time thank you for your help on the event corporate issue. Appreciate you, man. That was a lot of work we did on that. It's spread that away. And you meant a lot to us up here in your support of that, and I appreciate it. And it was great to communicate on that. And also, Richard, if he's there, I don't know if he's there. I want to thank him again for some help that he's given my company and some other stuff. My only comment, I don't really have much. I understand we got to move ahead with these wood destroying pest inspection reports. My God, they've been the same I know they've been the same for 35 years. After I did after the first revision on the mold stuff. So I'm glad to see that hopefully we're getting online with that. And, you guys are moving ahead and in that arena. And I think that's great. And I appreciate you guys in this effort. Thank you.
Do you have any other comments in Sparks?
For the record, this is Dan Sloan, Sparks. And there are no other comments from Sparks.
Do we have any comments from Elko or online?
Megan Brown, for the record, no, there is no public comment in Elko or online.
The department is proposing changes to Nevada Administrative Code, Chapter 555. These regulation changes are necessary and intended to assist the department in modernizing the reporting of wood destroying pest inspection forms. Physical wood destroying pest inspection report forms are currently provided by the NDA to industry free of charge pursuant to current regulations. The NDA anticipates modernizing the digital report forms will be a benefit to industry and the department. Current regulation requires the use of these signatures for electronically submitted reports, and updating the type of signature will enable us to use existing technologies and department resources to modernize the process. We'll review the proposed changes in detail, but to provide context for why the department is proposing these changes, I'd like to give a brief overview. The proposed changes modifies NAC section 555-430 to change the type of signature required when an electronic form being used from a digital signature to an electronic signature. Current definitions in Chapter 720 of NRS define digital signature and an electronic signature, and the provisions for digital signatures require cryptographically signed certificates. Electronic signatures are simply a digital mark provided by the person signing. So we'll now take any questions regarding the proposed changes to LCB file R005-25. A quick reminder, use the hand raising feature or come to the table to be called on. And be sure to state your name and affiliation for the record. Please keep your questions to 3 minutes or less to ensure everyone has a chance to be heard. As a reminder for anyone who's joined us on the phone, you can raise your hand by pressing *5. And once you've been called on, you can press *6 to unmute yourself. Do you have any questions or comments in the Sparks office?
For the record, this is Vance Lum from the Sparks office. Sir, would you like to ask questions? At this time, we have no questions from the participants.
Do we have any questions in Elko?
Megan Brown, for the record, no, there's no questions in the Elko office or online.
Thank you. Appreciate everyone's questions. We'll now move into public comment for anyone wishing to make a statement for the record and for consideration. Do we have any general comments in Sparks office?
For the record, this is Vance Lum in the Sparks office. No comments, sir. There are no comments in the Sparks office.
Do we have any comments in Elko office or online?
Megan Brown in the Elko office, there is no participation or participant questions in the office or online.
Thank you. Thank you all for your participation. The NDA will take the comments from today under consideration along with any written comments received during the rulemaking process. Following this workshop, there will be a hearing for adoption of regulations scheduled and communicated. The notice for the hearing will be posted not less than 30 days prior to the hearing date and will provide instruction as to how to provide written comment and a deadline for submission of comment for the purpose of being included in the official record of the hearing for adoption. Thank you for attending. This workshop is adjourned as of 3:02 p.m.